Welcome to the Boulder Criminal Defense Lawyer Podcast. I'm your host, Elena Nicole, and today I'm here with Allison Gordon. Allison Gordon is a criminal defense attorney with a strong reputation in Colorado's juvenile defense community. She has extensive experience in handling cases involving young people at every stage of the legal process, and she's known for combining compassion with determined advocacy to help clients and their families navigate incredibly difficult situations. So, Allison, thanks so much for being here today. I'm looking forward to this conversation.
Thank you so much for having me.
Yes, of course. So let's start off with some of the basics. We hear the term juvie thrown around a lot. Can you explain to us exactly what that is? And is it the same thing as juvenile jail?
That's a great question. In Colorado, there are two different ways that a juvenile could become incarcerated. The first is when a juvenile might become detained before being adjudicated or convicted of the crime of which they are accused. And the second is a commitment to the Department of Human Services or the Division of Youth Services, which is the equivalent of prison for a juvenile. And so both of these places are broadly referred to as juvie. Sometimes they both take place within the same building, but they're two different systems within the juvenile justice system where a juvenile could become detained or committed.
Interesting. Okay, well, thanks for clarifying that. So what is the youngest age that a child could be sent to juvie?
So in Colorado, the age of criminal responsibility is 10. However, there are certain protections in the law for juveniles between the age of 10 and 12. Generally speaking, it's very uncommon for a juvenile under the age of 12 to become incarcerated at the Division of Youth Services. However, once a child reaches the age of 12, the full panoply of punishments and consequences that apply for juveniles are on the table. So while a juvenile as young as 10 can be held criminally responsible, generally speaking, custody and custodial circumstances such as detention or commitment don't come into play until the age of 12.
Okay. And you said generally. So is there a time that wouldn't apply? And what would make that exception?
So under the Children's Code, if a very serious felony is alleged to have been committed by a juvenile under the age of 12, that juvenile could still be subject to detention and under some circumstances could be subject to commitment. However, given the types of cases that come into juvenile court and the ages at which juveniles typically are accused or convicted of those types of offenses, having a child under the age of 12 in detention or in commitment would be really exceptional.
Can you explain to us, break down a little bit what the difference would look like, whether it was detention or commitment?
Yes, detention is generally short term. A child is in detention while deciding whether or not they can be released under certain circumstances to be with their family and in the community pending the adjudication of the case against them. In juvenile cases, whether a child can be released to their family depends on two factors: the safety of the community and the ability of the family to supervise the child to ensure the safety of the community. It also is determined whether they may be a risk of flight from prosecution. And so in order to decide whether a juvenile will be released pre-trial, the court needs to look at what can be put in place to ensure that there's not a substantial risk of serious harm to the community were the child released. If the judge or magistrate finds that there's a substantial risk of serious harm to the community that can't be overcome by implementing community-based measures such as therapy, mentorship, a GPS monitor, pretrial supervision, or drug testing, then the juvenile would remain in detention pending the adjudication of their matter. Now, commitment is a sentence. Commitment is commitment to the Division of Youth Services, and a child is committed to the Division of Youth Services for rehabilitation if it's found that they could not be rehabilitated through a community-based sentence such as probation. And so commitment is, generally speaking, the strictest possible sentence for a juvenile who is tried in juvenile court. The exception being, of course, a juvenile who is tried as an adult.
In your experience, what types of crimes do you see juveniles most often come in for?
So generally speaking, the types of juvenile cases depend on the jurisdiction that I'm working in and also depend on the background of the juvenile. I work on cases in Boulder County, in Denver County, in Aurora, in Jefferson County. And I would say that the types of cases that I see most preeminently really depend on where I'm working. I would say that in Denver, motor vehicle theft, handgun possession, and assaults are most common, whereas in Boulder County, there are a lot of fights between children at school. There's a lot of interpersonal domestic violence type crime, family crime, and many sexual assaults that are prosecuted in Boulder County. And so I would say that the types of crimes that children are arrested for really run the whole gamut the same way that adults are accused of crimes. However, in urban areas, I think that crimes such as motor vehicle theft are extremely common, as well as all kinds of gun violence. When it comes to juveniles being charged as adults, only certain crimes are eligible to be filed into adult courts. And so when I'm working with a juvenile who's been charged as an adult, generally speaking, they are accused of either homicide, which is first-degree murder, and attempted murder. And almost always, those charges involve the use of weapons or firearms. Less commonly, there are forms of vehicular homicide. But when a child is charged as an adult, it must be a class 1 or 2 felony under most circumstances. And so those are generally homicides, including attempted murders. Direct filed cases could also be sexual assaults, kidnappings, but those homicide-related crimes are far and away the most common crimes where juveniles are prosecuted as adults.
What is the most common age group that you tend to work with? Is it on the younger side, in the middle, kind of on the older side? What do you see most?
I would say that usually between the ages 14 and 16 are when children start finding their way into juvenile court. Oftentimes, if I am working with a juvenile who is 11, 12, or 13, I'm hopeful that this might be a brush with the juvenile system that's not subject to repeating itself and could be a mistake that the child could learn from. However, if someone is getting involved in the juvenile system that young, it might be indicative of a greater problem, which needs to be addressed through resources and services. I would say that the most common age group I work with is 14, 15, and 16. And 16 is the threshold at which a juvenile can be directly filed into the adult court. So 16 and 17-year-olds are my clients whose cases are the most serious because those cases are being prosecuted in adult court if they are class 1 or 2 felonies.
Got it. Now, if a child is younger than 16 and it is a felony, like you mentioned, can it be tried in adult court or no, because it's beyond underneath that they're younger than 16?
That's a great question, Alina, and that's a really important question. The difference is that if a child is 16 or 17, the prosecution can initiate their case in the adult court, and then their defense team asks the judge to send the case back down to juvenile court. If the child is under 16, the procedure works the opposite way. The proceeding is initiated in the juvenile court, and then the prosecutor must ask the judge to transfer that case to the jurisdiction of the adult court. And so if a 12, 13, 14, or 15-year-old is accused of a very serious crime, the prosecution can ask the court to transfer that case up to adult court. But the presumption is that the case would start in juvenile court. And if the child is under the age of 12, they're not subject to transfer at all.
Okay. That's good to know. At what age, what is the youngest age that a child could be prosecuted?
In Colorado, the age of 10 is the age of criminal responsibility. And so 10 is the youngest that a child could ever be brought into the criminal system. Generally speaking, between the ages of 10 and 12, a lot of cases are dealt with through informal diversionary procedures. And under the age of 10, the only option is to deal with that case through informal rehabilitative services, in terms of figuring out what community-based options exist for that child, rather than bringing that child in to be adjudicated or accused of a crime in juvenile court.
Got it. And that still applies even if it would be a felony.
That's correct. And so even if a child is under the age of 10 and engages in conduct which would be a felony if they were over the age of criminal responsibility, it would not be possible for them to be prosecuted under Colorado's criminal code.
How often do you see that? Kids
I
that
don't.
young?
I mean, those cases don't really come to me. Generally speaking, if a child is under the age of 10, it would be extremely unlikely that they would be engaged in felonious conduct, such as motor vehicle theft, serious assaults, gun violence. However, I think that many people would be surprised by the amount of 10, 11, and 12-year-olds who are accused of engaging in felony conduct or sexually exploitative conduct. And usually those cases have to do with other underlying issues such as undiagnosed mental health conditions, dysfunction within the family, or those children themselves being the victims of abuse that has not been uncovered.
Yeah. And remind me, how long have you been doing this work?
So I graduated from CU Law in 2019. And so I became a lawyer in 2019. I've been a lawyer for approximately 7 years. However, when I was in law school, I did participate in the family and juvenile law clinic as well as the criminal and immigration law clinic for approximately 2 years. And so I'd say I'm going on 9 years of experience representing children, adults, indigent people, and people accused of crimes at all stages of the criminal process.
And the reason I ask is I was just going to ask from your experience if you've seen any changes or trends when it comes to either the ages of the children that you're working with or the types of crimes over the years.
That's a great question. I would say that one of the really big changes that I've seen in my practice has been the way that technology has impacted the crimes that children are accused of and the methods by which those crimes are alleged to have taken place, particularly the use of AI in creating alleged sexually exploitative material, threats being made towards schools through social media, bullying, and other types of targeted harassment being conducted through social media, in the investigation of alleged crimes being conducted through Snapchat, Instagram, Twitter, no longer Facebook, really. For those of us who are a little older, that's what we were used to, but that's not really in vogue anymore. And so while the crimes themselves, such as handgun possession, motor vehicle theft, I think have stayed similar, the methods of investigation and the methods of the planning and commission of alleged crimes, I think are always changing as technology becomes more advanced and more prominent.
Absolutely. That's so interesting. Well, Allison, thank you so much for joining us today and sharing your insight on such an important topic. We really appreciate this conversation.
Thank
And
you.
thank you to everyone for listening. And if you found this episode helpful, make sure to subscribe to the Boulder Criminal Defense Lawyer Podcast. And we'll see you next time. Thanks again, Allison.
Thanks, Elena. Bye.
Bye.